The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. Our next case is State v. Allroyd, and we'll hear from the appellant.
Mr. Chief Justice, and may it please the court, my name is Sarah Boyce, and I'm counsel for the appellant, the state of North Carolina. I'd like to reserve 5 minutes of time for rebuttal. 7 years ago, defendant pled guilty to the 1996 murder of a police officer and the attempted armed robbery of the Huddle House in Jonesville, North Carolina. The Court of Appeals unwound that plea deal because it believed, quote, binding precedent required it to do so. According to the Court of Appeals, this court's precedents impose a categorical rule that requires indictments charging any crime against a person to identify any alleged victims by name. Respectfully, the Court of Appeals was mistaken. There is no categorical rule that imposes a naming requirement for all crimes against the person or for armed robbery more specifically. Rather, indictments must simply include the essential elements of the alleged crime and must provide defendants with adequate notice and protection from double jeopardy. The indictment in this case satisfied those requirements. It included all three essential elements of the crime of armed robbery, and in so doing, it provided the defendant with adequate notice and sufficient protection for purposes of double jeopardy. For that reason, the decision below must be reversed. I'd like to begin with a case that the Court of Appeals felt controlled the outcome here in this appeal, and that's State v. Scott. State v. Scott was the linchpin of the decision below, and it's the focus of opposing counsel's brief here on appeal. The Court of Appeals below said, quote, we are bound by the reasoning of our Supreme Court in Scott, which clearly requires that the name of the person against whom the offense was directed be stated with exactitude. Respectfully, the state believes that Scott is not controlling here for several reasons. First, and perhaps most straightforward, Scott is a case that involves assault as opposed to armed robbery. And as this court well knows, because of the requirement that indictments must contain the essential elements of a particular crime, the rules that govern indictments alleging any specific type of crime usually are limited to that particular crime itself. It is not common for rules that govern one crime to translate or be imported from one case to another. And just as one small example, the rules for larceny, for instance, that an indictment must allege legal ownership of the property that's been targeted has been held not to translate to the crime of robbery because they are distinct crimes and because typically the essential elements of a particular crime only govern in that particular case. So if for no other reason, Scott can be discarded by this court because it is an assault case as opposed to an armed robbery case. But the problems with Scott go well beyond that. In Scott, the indictment charged the defendant with assaulting two different people, George Sanders and George Rogers. But as it turned out, the only person that the defendant had in fact assaulted was George Rogers. George Sanders was merely a mistake in the indictment. On those grounds, because the indictment contained a mistake that was not consistent with the evidence put forward at trial, this court held that the defendant's convictions needed to be quashed and arrested.
When you say the State versus Scott should be discarded, are you just meaning distinguished or are you meaning overruled?
Yes, sorry, Your Honor. I spoke imprecisely there. I simply meant that it does not control this particular case. The state has raised the question of exactly how much weight Scott should be given in light of the Criminal Procedure Act, but the state has not challenged State v. Scott here in large part because we don't believe that it controls here. We don't think that the holding of Scott is relevant to this case, and thus this court need not even consider whether it should be overruled.
Well, is it instructive at all in light of some of the other cases that have been cited both by the state as well as by the defendant?
I don't find Scott to be instructive in this particular case, Your Honor, because I believe that it is focused on what happens when an indictment contains a mistake, and no one has alleged that this indictment contains a mistake. In Scott, the problem was that the indictment cited a victim that the defendant had not, in fact, assaulted. So it would be the same as if, for instance, this indictment alleged that the defendant had tried to rob the employees of the Waffle House or a McDonald's or some other institution other than the targeted restaurant. There is no mistake here, and that was what the focus of this court was in Scott. It was the fact that the indictment contained a mistake, and thus the case is better classified as a case about fatal variances as opposed to the facial sufficiency of an indictment. The reason that we know that, Your Honor, is because the court said in Scott, quote, "A variance in the name of the person aggrieved is much more serious than a mistake in the name of the defendant." So what the court was focused on and what the court was referencing when it was talking about naming the victim with exactitude was the fact that the state needs to be accurate when it identifies a victim, not that the state needs to identify the victim with a particular degree of specificity, and more specifically, identify the victim with their specific legal name.
As long as I'm spending some time discussing some of this with you, I'll occupy it and then get out of the way for my colleagues. How did the majority make a mistake, in your view, in terms of saying that the specificity of the indictment here was not sufficient to give the defendant proper notice as to who the alleged victims were?
Well, so I think the main mistake that the majority made was in viewing Scott as controlling here, because again, as I said, I think Scott is inapposite here. I don't think that anyone has alleged that this indictment contained a mistake. So I think the first mistake was simply in regarding Scott as tying the hands of the court and controlling what the outcome should be here. In this particular case, of course, the indictment alleges that the defendant attempted to rob and endangered the lives of the employees of the Huddle House. So this indictment does identify a victim, and in fact, identifies a victim with a large degree of specificity. It identifies the employees of a particular restaurant at a particular address who are working on a particular night. So this is not a case where the state has failed to name a victim at all. It has simply declined to include the names of those particular victims. So as far as a specific mistake that the majority made below, I think it was regarding Scott as controlling the outcome here, but more broadly speaking, it was in holding that the specificity with which the victims in this indictment are named is not sufficient under this court's precedents.
The dissent does acknowledge a naming requirement, but goes on to say that nonetheless, the sufficiency of the notice as well as the prevention of double jeopardy was sufficient here. Are you fully embracing the dissent as you stand representing the appellant here?
Your Honor, I don't necessarily understand the dissent to acknowledge a strict naming requirement. I do think the dissent seems to indicate that a victim should be named. But my recollection of the dissent was that when it's discussing a naming requirement, it is quoting from the rule that the majority imposed. But I certainly agree with Your Honor that the key holding of the dissent below is that the specificity with which the victims are identified here is sufficient, and we fully embrace that as the rule and the holding that this court should adopt. We think it's quite clear that the indictment in this case provided the defendant with adequate notice by identifying the employees of the Huddle House as the victims who were endangered, and also that degree of specificity provides the defendant with adequate protection from double jeopardy. So as to that particular holding, absolutely, we agree with the analysis put forward by the dissent. Moving briefly.
Go ahead.
Yes, Your Honor. No, go ahead, Your Honor.
I was going to add, what we've got here as compared to an indictment charging a completed crime, we have an indictment charging conspiracy. Is there anything? Go ahead.
I was just going to say, yes, Your Honor, there is a separate indictment for conspiracy, but that is not the particular indictment that's at issue in this case. This is the indictment for attempted armed robbery, which is distinct from the conspiracy charge.
I'm misstating and appreciate the correction. The indictment charges attempt rather than a completed crime. I appreciate being set straight on that. I've got both of them sitting here, and
no problem, Your Honor. Thank you.
In either, but I think my question is the same. Is there anything about the fact that we have charged attempt as compared to a completed crime that should have any bearing on our analysis of the sufficiency of the indictment in this case?
No, Your Honor, I don't think so. Because of the way that the statute 14-87 defines armed robbery to include an attempted taking, and the way that this court's precedents have set forth the essential elements of armed robbery, whether it be attempted armed robbery or not. In both instances, that first element focuses on the taking of the property and sweeps in both an actual taking or an attempt. So it is not the state's position, and I don't think it's the defendant's position, that the fact that this was attempted armed robbery as opposed to simply armed robbery makes a difference in this particular case. Moving briefly back to State versus Scott and the notion that this case is not focused on any naming requirement, I would also point out that the key case that Scott relies on is this court's decision in State versus Angel. That's a case from the 1850s that similarly looked at the question of how specific an indictment needs to be in naming a victim. And what the court said there was, it is certainly a best practice for an indictment to identify a victim by name, but it is not required. As long as the state identifies a victim in a way that distinguishes that victim from others, that is sufficient. And the state went on, or the Supreme Court went on to say in Angel, if for whatever reason the state is unable to identify a victim, the victim's name, then that will not preclude the state from pursuing charges via indictment either. So it would be curious indeed if State versus Angel was the key opinion cited in Scott, and yet Scott were taken to stand for the rule that a naming requirement does exist, given that State versus Angel expressly rejects the idea that indictments do contain, must identify victims by name to be facially valid. I also would like to note briefly that it's quite telling how much emphasis both the court below and opposing counsel have had to put on Scott. You would think, given the broad range of crimes against the person and the long history of this court's precedents that address various crimes against the person, that if there were a categorical rule that imposed a naming requirement, that rule would have been cited time and time again in this court's precedents in exactly the same way that this court has time and time again said that indictments must include the essential elements of the crime. And yet the only case from this court that the court below or opposing counsel has cited that supposedly imposes this sweeping naming requirement for all crimes against the person is State versus Scott. And I think for the reasons I've already explained, that case is distinguishable and doesn't apply here. But even so, the dearth of any other precedent is telling in this particular case. I do want to touch briefly on two cases that I think are more relevant here, and those are State versus Angel and State versus Spillers, or excuse me, State versus Rogers and State versus Spillers. State versus Rogers is an armed robbery case, and in that particular case, the defendant argued that because his indictment did not provide the specific time or place of the robbery, that it was facially invalid. And this court in Rogers rejected that argument. Of course, the defendant there could have made similar arguments to the defendant in this case and said that it would have been more helpful in terms of notice and double jeopardy if the indictment had provided a specific time and place in terms of clarifying exactly what he had been charged with. But this court rejected any such argument and again reiterated that so long as an indictment contains the essential elements of a crime, that is sufficient for purposes of this state's law. Similarly, in State versus Spillers, as the dissent explained below, this court rejected the idea that an indictment must name the victim whose property is targeted. Of course, in the vast majority of armed robbery cases, that victim is going to be the same person whose life is endangered. So it would be strange indeed if State versus Spillers stood for the proposition that the owner of the property need not be named, but that if that person is the same person whose life is endangered, a name must be included. So I would direct the court to both of those two cases as being far more persuasive in this particular context, and as supporting the notion that there is a lot of play in the joints in terms of the way that the state can charge crimes, so long as they are sure to include the essential elements of the particular crime in question. And again, that it is clear that the state has done so here. It has included all three of the essential elements. I do want to pause briefly to note that the state does not dispute whether it would as the court said in State versus Angel, be the best practice for the prosecution to ordinarily include the name of the victims in this case. If the court were to look through its precedents addressing armed robbery, it would find that in the vast majority of cases, the state does indeed include the names of the victims and identifies them by name. But there are rare exceptions where that is not possible, and the state submits that it would obstruct justice in those particular instances if the state were required to comply with a rigid rule of that kind. I don't want to represent anything that's not in the record here. The record does not exactly make clear why these indictments did not contain the names of the victims in question. But of course, one possible explanation might be that the crime had occurred in 1996, and then the case went cold until 2012. And in that amount of time, it is possible that the state was no longer able to identify exactly who the employees were that the defendant and his accomplices explained that they saw at the Huddle House on the evening when they tried to rob it, and ultimately ended up killing the officer in this case. So again, the state would be perfectly comfortable with a rule like the one articulated in State versus Angel, which suggests that it is the best practice for prosecutors to include the names of the victims wherever possible, but a rule that recognizes that there are exceptions where doing so is not possible for one reason or another. And I think many of this court's precedents make clear that the court and the General Assembly in this state have shifted away from a rigid approach to indictments that would tie the hands of the state in those rare instances where it is not possible to be more specific than the state has been in this case. I do want to also touch briefly.
Sorry, can I just
Sure.
ask a question about that point? So it sounds like you're saying the rule should be as long as the essential elements of the crime are alleged. If it's not possible to actually name the victim, the indictment should still be sufficient. But doesn't that impossibility raise problems on the double jeopardy side? Because if it's not possible to name with specificity the victims are, then how would it be possible to know in the future who the defendant was actually convicted of assaulting?
Well, Your Honor, so I do think that it could pose problems with respect to the state's ability to prove its case if the case proceeds to trial, but I don't think it poses double jeopardy problems. And if we take the facts of this case, I think I can explain why. Here we, of course, have an indictment that charges the defendant with attempting to rob the employees of the Huddle House on a particular evening. And if this case had proceeded to trial and the defendant was then acquitted, and the state ultimately chose to re-indict this case and then in that instance name the particular Huddle House employee, all of the defendant would need to do would be to move to quash the indictment and put forward evidence that the named person in the subsequent indictment was a Huddle House employee on that evening. So I don't think the lack of names here actually opens the defendant up to any double jeopardy problem, because again, it does identify the victims with sufficient specificity that the defendant down the line would be able to say, wait a second, this person that I have later been charged with attempting to rob falls within the class of persons that was in the prior indictment, and specifically here, these Huddle House employees. And were the defendant able to put forward that evidence, as you would expect he would be, then the state would not be able to proceed with that subsequent prosecution. I have not heard opposing counsel identify any particular hypothetical scenario where the state would be able to come up with another way of charging this crime that would not be barred by the indictment in this particular case. And I gave the example of specifically naming the Huddle House employees in a future case. And I think that would certainly be one theoretical possibility that would be barred. But even if the state were to try to move forward with a different charge, like saying that customers at the Huddle House had been barred or had been targeted by the defendant's alleged crime, that too would be barred by this particular indictment, given the way that armed robbery is conceived of in this state. And more specifically to that point, this court's precedents hold that so long as the same property is targeted, the presence or existence of numerous victims on the scene of the crime does not convert the offense into numerous counts or numerous crimes. So again, for that reason, because we have specific property targeted here, I have not been able to hypothesize any possible crime that the state could charge Mr. Oldroyd with in the future that would not be barred by this indictment. And again, I haven't heard my friend on the other side propose a possible indictment either that might be able to proceed despite the one in this case. So I do think the lack of any argument on that front is significant here. I have not heard Mr. Oldroyd argue that he lacked notice in this particular instance. I do think that this indictment is quite clear as to who did what and when, which is the question that State versus Sturdivant suggests is the relevant inquiry with respect to notice. I think this indictment clearly seems to describe who did what and when on the evening in question in 1996. And then again, the other relevant question would be whether he's protected to double jeopardy, and the state would submit that he is. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. May it please the court. My name is Emily Davis. I'm with the Appellate Defender's Office, and I'm privileged to be here today on behalf of Mr. Oldroyd. Your Honors, this indictment is defective because it doesn't do the constitutional work it's supposed to do. The indictment doesn't protect Mr. Oldroyd from double jeopardy because it doesn't identify any employee. So the indictment doesn't affirmatively protect him from prosecution for attempted armed robbery of any named employee. And that's why this indictment is defective. The first thing I'm going to discuss are the reasons this indictment doesn't protect him from double jeopardy, including a hypothetical example. And after that, I have one or two final points to make. Your Honors, the first key to understanding this double jeopardy problem here is that the attempted armed robbery of multiple employees can support multiple counts of attempted armed robbery. And Beatty, that's B-E-A-T-Y, tells us that the attempted taking of business and personal money from each employee that's endangered constitutes a separate count of attempted armed robbery. The second thing is that this indictment doesn't limit this to a single offense. It doesn't say one employee was endangered, and it doesn't say that there was an attempted taking of only Huddle House money. So the indictment itself doesn't limit us to a situation like Ballard, for example, where multiple employees are endangered during the taking of only business money. So there's no argument that this indictment could only cover one offense. And the factual basis doesn't limit us in that way either. We can't use the factual basis to fix this defective indictment, but we certainly can use it to explain the double jeopardy problem. And the factual basis is these guys ran out of money. They planned to rob a restaurant to get money and tried to rob employees. And nothing suggested an attempted taking of only Huddle House money instead of all the money from these employees. And Beatty tells us that that would support multiple counts of attempted armed robbery. So considering all that, we look at the indictment here that just says employees were endangered. If there were 6 employees there that night, that's 6 counts of attempted armed robbery. We have no idea which one this indictment is talking about because it doesn't name anybody. So the indictment doesn't protect Mr. Oldroyd from prosecution for attempted armed robbery of any named employee. So if Emily Davis goes to the DA and says, I was an employee of that Huddle House and I was there that night when this happened and these guys flashed a gun and I was endangered and they tried to take my money. This indictment doesn't protect Mr. Oldroyd from prosecution for attempted armed robbery of Emily Davis or any other named employee.
What's your reaction to the dissent's position that in such a situation, the defendant can demand a bill of particulars?
Well, Your Honor, the name of the victim for a crime against the person is material and essential information. It's how we distinguish one attempted armed robbery from another, or one assault from another assault. So the defendant could ask for a bill of particulars, but a bill of particulars couldn't cure this because the name of the victim is material and essential information.
Wouldn't the bill of particulars put the state on notice that it needs to supply more specificity, such as who the alleged victims are?
I believe it would put the state on notice, but the rule for the bill of particulars is that it can't fix a defective indictment by supplying essential information. And a defendant might ask for a bill of particulars for something non-essential, when that doesn't mean that the trial court has to grant it. But here, the bill of particulars couldn't fix this defective indictment anyway.
So your position is firmly that on its face, the indictment is deficient and unconstitutional because it does not give sufficient notice?
Your Honor, the argument is, yes, this indictment is defective on its face, and the main reason is because it doesn't affirmatively protect him from double jeopardy. For the same reasons, it doesn't give the required notice, because it doesn't clearly identify which attempted armed robbery it's talking about. For
Ms.
some of the
Davis,
reasons.
let me follow up on that. As I understood the state's argument, it would protect him from prosecution in the future for another robbery attempt charge against any of the employees who were there on that night. That if there was an indictment that charged a crime against any of those employees, and they could show that they were employees of the Huddle House on that night, that the indictment would be quashed. Why is that not sufficient protection?
Well, the indictment itself, in the four corners of the indictment, it is supposed to affirmatively protect someone and from double jeopardy. And the fact that, and the state conceded this in its reply brief and today also, that if the state charged Mr. Oldroyd with attempted armed robbery of a named person, that Mr. Oldroyd would have to file a motion to dismiss, and he would have to present evidence establishing that the person named in the indictment was an employee who was there that night. And that demonstrates exactly why this indictment is defective, because the indictment itself does not affirmatively protect Mr. Oldroyd from prosecution.
Mr. Davis, let me ask you something to perhaps illustrate that there are decisions on the subject of which I'm not aware. I'm aware of many decisions that say that the facial sufficiency of the indictment has to be determined based solely on the language of the indictment itself. Right off the top of my head, I'm not coming up with one that says that to the extent that you use an indictment for purposes of protecting yourself against double jeopardy, all of the information necessary to support such a double jeopardy claim has to be in the indictment itself. Is there a decision that holds that?
Well, I believe the cases that discuss how an indictment has to be sufficient itself, that's Guffey and Benton, Ellis, White, and Corey, I believe, are the main ones.
They say that they have to be sufficient to permit someone to advance a double jeopardy claim. Do they say that you have to, that all of the information necessary to support the validity of that claim has to be contained in the bill of indictment?
Well, for this particular issue, the naming of a victim, identifying a victim, and the failure to do that is what makes this indictment defective.
I mean, I understand that's your argument. What I'm asking you is can you tell me a case that holds that the indictment has to contain all of the information necessary to support a double jeopardy claim?
Your Honor, I don't know a case that says exactly that.
Okay.
But I think cases that would support that proposition are Scott, Bell, Call, and Abraham. Bell, Call, and Abraham all say that an indictment, I think it was an armed robbery indictment and assault indictments, have to accurately allege the name of the victim. Otherwise, there wouldn't have been fatal variances in those cases.
While I'm at it, one of the reasons Ms. Boyce was not too impressed with this question, let me see get your response to it as well. At least as I understand the facts of this case, we've got an attempt charge, not a conspiracy charge, but a contempt charge, an attempt charge. At least as I understand the facts, the defendant neither the defendant nor any of his collaborators even got to the Huddle House sufficiently to start committing robbery. They got to the back door, but then turned around for various reasons. So that the defendant never knew who was in the Huddle House, if anybody. Does that make a difference?
Well, again, we're just looking at the indictment itself, we can't consider that. But speaking in terms of the double jeopardy problem here, I don't know that makes a difference to this argument. The factual basis that was presented, viewed in the state's favor, would support a reasonable inference that they tried to rob these employees of what.
But at least given how far they got, that they would not have known who any of them were, other than that they were employees or people inside the Huddle House, right?
Would the co-defendants and Mr. Oldroyd know?
Yes.
I don't think there's anything in the record that would allow me to say they knew who the employees were.
And in your view, at least the fact that, assuming that there was, the only thing that the record would support was a suggestion that the attempt was being made upon whoever happened to be in the Huddle House at the time, in your view, that doesn't make a difference.
I think that is supported by the record, that the plan was to rob all the money from whoever was there.
All right, thank you.
Your Honors, I have two final points to make. And the first one is that this is not one of those technical problems or the omission of non-essential information. This is a substantive constitutional problem with this indictment, because the failure to identify any victim means that this indictment doesn't affirmatively protect Mr. Oldroyd from double jeopardy. And the state can't identify any case where the court has said that an indictment for a crime against the person is legally sufficient when it fails to name any victim. This indictment is defective, and the Court of Appeals decision should be affirmed. One final point I have is about Scott, and I think that Scott is important for two reasons. It talks about the indictment requirements. An indictment has to be sufficient enough to identify the particular crime it's talking about, so that it affirmatively protects someone from subsequent prosecution for the same crime. And those indictment requirements have been recognized again and again by this court as being required by the Constitution. Article 1, Section 22, sometimes 23 is also cited. And examples of those cases include Greer, Stokes, Sturdivant, Hunt, and White. And the rule about how an indictment for a crime against a person must identify a victim or name a victim is a rule that makes sense considering these constitutional requirements for indictments. The name of the victim is how we distinguish one particular transaction from another. And I know that The short form statutes certainly aren't controlling here, but those statutes contain what is needed for an indictment to comply with these constitutional requirements. And those short form statutes for sex offense, rape, and homicide all specifically require that the indictment has to allege the name of the victim, because that is how the particular transaction of the crime is identified and distinguished from another. And that's how an indictment protects someone from double jeopardy.
Aren't those required by statute, that type or those types that you just mentioned? Aren't those in the statutes that define the offense themselves?
1487, I believe, says person or victim.
Well, I'm talking about like sex crimes, for example. I think that was in the opinion of the Court of Appeals. I believe it talked about I think it's in either the dissent or the majority, about 5 cases. And of those 5 cases that were cited, 3 were sex crime cases in which the defined offense by statute had to include the victim's name or alleged victim's name.
Yes, Your Honor. And again, I understand that obviously there's no short form statute here, but the legal principles that apply there are equally applicable here in some respect, because those short form statutes say what must be in an indictment so that it meets these constitutional requirements. And I think it's very significant that those require an indictment to name a victim. Your Honors, that's all I have today on this defective indictment. So unless there are any other questions, we would ask that the court affirm the Court of Appeals decision. Thank you very much.
Thank you. Any rebuttal?
Yes, Your Honor. First, my friend on the other side stated that the state has been unable to come up with any cases where this court has said that an indictment for a crime against the person need not name a victim. And I don't believe that's true. State versus Angel is a case that involves homicide, which of course is a crime against the person. And in that case, this court specifically said that the state need not name a victim in every case, and that where the state is unable to name a victim, that does not render the indictment fatally deficient. So that would be one case. State versus Spillers, which the dissent below would be another case. Of course, State versus Spillers is another armed robbery case, and in that particular opinion, they're focused on the identity of the victim whose property is targeted. But it would be another case where this court has rejected the notion that indictments must always identify victims by name. So those would just be 2 examples. I'm glad that this court, that I think Justice Morgan is focused on the sex offense crimes in particular. I think it is significant that those statutes require a name, but for the opposite reason that opposing counsel has cited. If in fact there were already a rule that all crimes against the person must name a victim, there would be no reason that those statutes would need to include a naming requirement. The only reason that those statutes have to include that requirement in the first place is because there is not this sweeping categorical rule already that requires a naming requirement, that requires victims be named in any indictment that charges a crime against the person in the first place, just as a baseline principle. It seems to me that the focus of much of opposing counsel's beginning of her argument was focused more on the way that this indictment has specified the property that was targeted here and less on who the victims were whose lives were endangered. Opposing counsel pointed out that perhaps if the property of different employees were targeted, that might open up the defendant to different counts. And respectfully, that's not the issue here in this case. This case is focused on the specificity with which this indictment identifies the victims whose lives were endangered. And as Justice Hudson correctly summarized my argument on this point, the state's position is that if the state were to later try to charge the defendant with endangering the lives of any of these specific employees and identifying those employees by name, the defendant could simply move to quash that indictment and present evidence that those employees that those individuals were employees of the Huddle House at the time. Opposing counsel took issue with the idea that the defendant would have to move to quash the indictment, but that's simply the way that this works in practice. If the state does proceed with charges, a defendant will ordinarily, as a matter of course, move to quash that indictment on double jeopardy grounds. And
Ms. Boyce, I apologize to cut you off in your rebuttal, but to that point, and there's nothing in the record about discovery, but if discovery were provided in this case, and that discovery specifically identified the employees of the Huddle House, would that provide or afford some sort of protection against double jeopardy, or at least an argument against double jeopardy?
If I understand Your Honor correctly, you're asking whether that evidence could be used in a later prosecution to support the defendant's argument that a double jeopardy concern had arisen?
Right. If there were a subsequent indictment charging for the victim, John Smith, who was an employee, and John Smith had been identified in discovery, could that information be used in a subsequent motion to quash?
I believe so, Your Honor. So I think this gets at the point that Justice Ervin was making, which is about whether or not the double jeopardy protection has to come solely from the indictment on its face. And I think the answer to that is clearly no. Under the way that this court has articulated the same evidence rule, you can prove a double jeopardy problem either by looking at the face of the two indictments, that's the first way it can be proven, or by looking at the evidence that arose over the course of the first trial. So I'm not sure that this court has ever talked about discovery that came up in the course of the prosecution, but certainly if there were evidence put forward in a trial, had there been a trial in this particular case, this court could look to all of that evidence in ascertaining whether in fact a subsequent prosecution was for the same crime. So there is no rule that the only thing that the court could look to in a subsequent prosecution would be the face of the indictment itself. Any evidence that had arisen could be used to support the defendant's argument that he had already been prosecuted for this crime.
Can I ask you a question about your interpretation of State versus Scott? And
Sure.
As I understand your argument, you start out by saying it doesn't really apply here because it was about assault and this is an armed robbery. But does that mean that if we reverse the Court of Appeals and hold that in an indictment for attempted armed robbery, it is not necessary to name the victim, does that mean that the state of our law will be that for an assault, a name is an element of the indictment, but for an armed robbery, it is not?
I don't think so, Your Honor, because again, I don't think the holding of Scott is that for an assault, you have to name the victim because, of course, the victim was identified by name in Scott. That was not the problem. The indictment contained the victim's name. It just got the victim's name wrong. So I don't think that the holding of Scott is that a victim must be identified by name. But assuming this court were to agree with the Court of Appeals that that is the rule that's put forward by Scott, in other words, that Scott does hold that a victim must be named, then yes, I do think that could be distinguished from this case based on the distinction in the crimes. And thus, yes, there would be different rules for armed robbery and assault.
And what would be the principled reason for making that kind of distinction between assault and armed robbery?
One reason would just be simply because based on the way that the common law in this court has developed, there are often different rules for different crimes. But another would be that I think because of the distinct elements in armed robbery and the way in which the indictment can provide details about the conduct in different ways. So in this particular instance, by also providing details about the restaurant that was targeted and the weapons that were used, the identity of the victim is not quite as critical in an armed robbery case as it might be in an assault case, where there's not the same breadth of various elements that can be used, that you can kind of layer on with different details in the indictment to clarify exactly what conduct is being charged. So I simply think that the various elements involved in armed robbery and the way that they are alleged in an indictment gives a clearer picture of the who did what when standard that Sturtevant sets forward that might not be true in assault. But again, I do want to be very clear that the state does not believe that Scott in fact imposes a naming requirement for assault either. In our view, Scott is a variance case, not a case about facial sufficiency of an indictment. And Justice Urban has some helpful language in a recent opinion called State versus Ellis that speaks to how much that speaks to the difference between cases involving variances and cases involving facial deficiencies in indictments, and makes the point that you can't necessarily translate holdings from one of those contexts into another in the way that I think we would be doing if the court were to apply Scott here. Again, the state does not dispute that in the mine run of cases, the best practice would be for prosecutors to include the name of the alleged victim. On rare occasions, however, naming a victim may not be possible. When those rare scenarios arise, this court's precedents make clear that it would be wrong to tie the hands of the state with overly rigid pleading requirements or categorical rules. Yet that is precisely what the Court of Appeals has done here. It has tied the hands of the state with a newly minted naming requirement that elevates form over substance. The decision below should be reversed. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.